Hello and welcome back to LiveLaw Daily. Today, the 5th of August marks an important milestone in India's legal history. On this day in 1991, Justice Leela Seth became the country's first woman Chief Justice, taking charge of the Himachal Pradesh High Court. Years earlier, she had already made history by topping the London Bar Examination in 1958, the first woman ever to do so. With that, let's turn to today's major developments from courts across the country. Our first story deals with Trinamool Congress Member of Parliament Abhishek Banerjee's request to travel abroad for medical treatment, a request that the Calcutta High Court has now refused. Banerjee had approached the court seeking permission to travel to the United States for treatment of an eye condition. His lawyers told the court that he had already undergone 2 surgeries at Johns Hopkins Hospital and wanted to continue treatment with the same specialists. They also pointed out that he had traveled abroad several times between 2023 and 2025, always returned to India and had cooperated with the investigation in the criminal cases pending against him. But Justice Saugat Bhattacharya repeatedly asked a simple question. If the required treatment could be provided in India, why was it necessary to travel overseas? To answer that, the court proposed that Banerjee first be examined by a medical board at Kolkata's SSKM hospital. Senior advocate Rebecca John, appearing for Banerjee, declined the suggestion. She argued that continuity of treatment with the same specialists was more important and that Banerjee had the right to choose where and by whom he would be treated. She also relied on the Maneka Gandhi judgment to argue that the right to travel abroad forms part of the fundamental rights guaranteed under the Constitution. The court, however, said it could not rely solely on the medical opinion produced by Banerjee, especially when the doctor's credentials were not fully disclosed. Since Banerjee refused to appear before the medical board, the court held that it had no basis to conclude that treatment abroad was medically unavoidable. With that, it dismissed his application seeking permission to travel overseas. Our second story deals with deepfake videos targeting Union Minister Nitin Gadkari and a significant order from the Bombay High Court on online misinformation. The High Court has directed the takedown of several AI-generated deepfake videos that falsely linked Gadkari to the centre's E20 ethanol blended fuel policy. The videos allegedly claimed that Gadkari and his family had personally benefited from the policy and accused him of corruption, nepotism, and misuse of office. According to Gadkari's plea, these allegations are completely false. He pointed out that while he has been the Union Minister for Road Transport and Highways since 2014, the E20 fuel policy falls under the Ministry of Petroleum and Natural Gas, and he has no role in framing or implementing it. Importantly, Gadkari told the court that his petition was not an attempt to silence criticism. His plea specifically states that he does not seek to prevent fair debate or criticism of government policies, but only the removal of content that is false, fabricated, malicious, and defamatory, including deepfake videos created without his consent. While ordering the removal of the content, Justice R.F. Doctor also made a broader observation. He noted that there is currently no effective mechanism to automatically remove such abusive or fabricated content, forcing individuals to approach courts each time they seek relief. Gadkari has identified at least 24 posts in his petition, and the matter will now continue before the High Court as it examines the larger issues surrounding deepfakes and online accountability. Our third story deals with another hearing before the Supreme Court on the recent student protests. But this time, the focus was on whether the cases against the protesters should be withdrawn at all. A fresh petition has been filed by Manish Kumar Solanki, asking the court to prevent the union government and the states from withdrawing rioting cases merely because of a political understanding. The petition was heard by a bench of Chief Justice of India Suryakant, Justice Joy Malia Bagchi, and Justice V. Mohana, which tagged it with other pending protest-related matters. Arguing for the petitioner, Advocate Rizwan Ahmed said that the issue was not just about alleged police excesses, but also about the accountability of those who organized the protests. Referring to the protest organizers without naming the Cockroach Janata Party, he argued that they were continuing to make provocative statements and should not escape responsibility. At one point, he cautioned the court by saying, "Tomorrow, Generation Alpha, Beta, Delta will come," warning that withdrawing cases could set a dangerous precedent. The Chief Justice, however, took a more measured approach, as he observed that the government's decision to withdraw cases may have been intended to prevent the situation from escalating further. These are youngsters. They need a lot of advisory consulting, the CJI remarked, adding that an aggressive response from the state could unnecessarily worsen the situation. He also stressed that the police must exercise restraint and said that the counseling and dialogue would often be more effective than punitive action. Apart from opposing the withdrawal of FIRs, the petition also seeks directions to identify those who allegedly abused or defamed police personnel during the protests through video evidence and asks that they be directed to perform supervised community service. The matter will now be heard along with the other pending petitions relating to the student protests. Our fourth story deals with the Supreme Court's refusal to step into an internal dispute within the Supreme Court Bar Association over a resolution supporting Sonam Wangchuk's hunger strike during the student protests. The petition challenged a resolution passed by the Supreme Court Bar Association Executive Committee, which had expressed solidarity with Wangchuk and criticized what it described as the lack of an adequate institutional response to the students' agitation. The petitioner argued that the resolution dealt with a politically sensitive issue and wrongly gave the impression that it reflected the views of the entire Bar Association. It was also argued that the Executive Committee had become functus officio after the election process had begun and therefore had no authority to pass such resolution. But the bench of Chief Justice of India Suryakant, Justice Joy Mallya Bagchi and Justice V. Mohana declined to interfere. Justice Bagchi observed that there is a difference between an undemocratic decision and an illegal one, and said that if members disagreed with the resolution, their remedy was to invoke the democratic processes available within the Bar Association itself. The judges also cautioned against courts stepping into such internal matters. Justice Bagchi remarked that judicial interference would set a dangerous precedent, while the Chief Justice asked the petitioner to gather support and seek a general body meeting under the association's rules. The court ultimately disposed of the petition while giving the petitioner liberty to pursue the remedies available under the SCBA rules, including approaching the election committee. Our next story deals with another development in the case involving former Tamil Nadu Minister Senthil Balaji, and this time concerning the conditions of his anticipatory bail. The Madras High Court has relaxed the bail conditions imposed on Balaji and his brother R.V. Ashok Kumar in a case linked to allegations that a 35 crore bribe was offered to a TVK MLA to influence his vote in the election for the Assembly Speaker. When the court granted anticipatory bail in July, it had directed both men to appear before the police twice every day and cooperate with the investigation. However, the court has now modified that condition after noting that a division bench of the High Court has already stayed the investigation in the case. In view of that stay, the judge said that the requirement of daily appearances was no longer necessary. At the same time, the court clarified that both Balaji and his brother must appear before the police whenever they are summoned. The case began after TVK MLA N. Ilayaraja alleged that he had been offered 35 crore rupees to vote in favor of a proposed move against the Assembly Speaker and was threatened with consequences if he refused. During the investigation, the police claimed that the offer was made at the behest of Senthil Balaji and his brother. Balaji has denied the allegations throughout, maintaining that he was never named in the original FIR and that there is no evidence directly connecting him to the alleged conspiracy. Our next story deals with a strong reminder from the Allahabad High Court that the police cannot ignore constitutional safeguards while making arrests. The court made some sharp observations about the way arrests are often carried out. It said that the police have traditionally paid scant regard to Article 22, Clause 1 of the Constitution, which guarantees that every arrested person must be informed of the grounds of their arrest. The judges also remarked that police officers often fail to appreciate the importance of fundamental rights and tend to assume that every accused person is guilty. These observations came while the court quashed the arrest and remand of a man named Rakesh, holding that he had never been properly informed of why he was being arrested. A bench of Justice J.J. Munir and Justice Tarun Saxena examined the arrest memo and found that it only contained standard printed reasons like preventing tampering of evidence or ensuring the accused person before the court. It did not explain the actual factual grounds on which he had been arrested. Relying on recent Supreme Court judgments, the High Court emphasized that there is a clear difference between reasons for arrest and grounds for arrest. Since this constitutional requirement had not been followed, the court held that the arrest itself was illegal, regardless of the seriousness of the allegations. The High Court also criticized the magistrate for mechanically authorizing judicial custody without checking whether Article 22, Clause 1 had been complied with. Along with ordering the petitioner's release, it directed the Sessions Judge of Sambhal to ensure that magistrates do not authorize remand through printed formats without first verifying that the constitutional safeguards have been respected. Our next story deals with the Supreme Court's push to increase the retirement age of judicial officers across the country, and a clear message to states that money cannot be an excuse to oppose it. The issue came in the long-running All India Judges Association case, where a bench of Chief Justice of India Suryakant, Justice Joy Mallya Bagchi, and Justice V. Mohana is considering whether the retirement age of members of the district judiciary should be raised from 60 to 62 years. Several states opposed the proposal, mainly on two grounds. First, they argued that extending the retirement age would create an additional financial burden. And second, they said that it would create a difference between the retirement age of judicial officers and that of other state government employees. The Supreme Court rejected both the reasons. On the financial argument, the bench said experienced judicial officers are an institutional asset. Keeping them in service would actually reduce the need for immediate recruitment, training, and induction of new officers, making the concern of additional costs untenable. The court also made it clear that judicial officers cannot be equated with ordinary government servants. It observed that although they are appointed by the state, they form a distinct and separate class, and therefore comparisons with the retirement age of other government employees are misplaced. The court has now directed all states that opposed the proposal to reconsider the issue independently within 2 weeks. It also clarified that states are free to approve an increase in the retirement age even if their respective high courts have expressed reservations, adding that the views of the high courts will be examined separately at an appropriate stage. Our next story deals with the long-running 2003 Muthanga land struggle case, where 4 convicted persons have now challenged their conviction before the Kerala High Court. The case goes back to the Muthanga Wildlife Sanctuary in Wayanad, where Adivasi protesters, under the banner of the Adivasi Gotra Mahasabha, had occupied forest land. A police eviction drive turned violent, with police firing 18 rounds. 5 protesters eventually lost their lives, and police constable KV Vinod was also killed. Among those now before the High Court are social activist M. Geethanandan, along with Binu, Rameshan, and Anil Kumar. Last week, a sessions court convicted them of offences including rioting, unlawful assembly, causing injuries to public servants, criminal intimidation, kidnapping, and attempt to murder, sentencing them up to 5 years rigorous imprisonment. However, the same court acquitted them of the charge of murdering Constable Vinod, holding that the prosecution had failed to prove any criminal conspiracy beyond reasonable doubt. That finding is now at the heart of their appeal. The appellants argue that the trial court could not rely on a prima facie finding of conspiracy to convict them on other charges after concluding that conspiracy itself had not been proved at trial. They have also questioned the legality of the CBI investigation, arguing that the agency failed to establish the necessary legal authorization to take over the probe and claim it conducted a fresh investigation instead of the limited further investigation it had been permitted to carry out. They further allege that key witness statements, video evidence, and procedural safeguards were not properly handled, making the convictions legally unsustainable. The Kerala High Court will now examine these challenges in appeal. And our final story deals with a Karnataka High Court order that came down strongly against a man under investigation by the Enforcement Directorate for trying to get the investigating officer changed. The petitioner, who is allegedly linked to the Christian missionary organization called the Timothy Initiative, had approached the High Court after sending representations to the Chief Justice of India, to the Chief Justice of the Delhi High Court, the Union Finance Minister, and the Enforcement Directorate, seeking the replacement of the Enforcement Directorate officer investigating him. Justice Suraj Govindraj made it clear that a person under investigation has no right to choose the investigating officer and strongly criticized the petitioner's decision to involve high constitutional authorities in what was essentially an investigative matter. The court said that such conduct deserved to be deprecated in no uncertain terms. The High Court has dismissed the plea for a change of the investigating officer and imposed costs of 1 lakh rupees directing the amount to be paid to the Karnataka State Legal Services Authority within 15 days. At the same time, the court granted limited relief by directing airport authorities and the CISF to preserve CCTV footage covering the period when the petitioner was intercepted at the Bengaluru airport in April this year. The case is linked to the ED's investigation into allegations that foreign debit cards were used to channel around 92.5 crore rupees into Naxal-affected regions. According to the agency, over 1,000 such cards were allegedly distributed across India, with large withdrawals reported from several states. The investigation is continuing. And that's all for today's edition of LiveLaw Daily. If you'd like to read any of today's stories in full, you'll find the links to our reports in the description box below. For continuing coverage of the Supreme Court, the High Courts, and important legal developments from across the country, keep following livelaw.in. Thank you for listening, and we'll be back tomorrow with another roundup of the day's biggest legal stories.